This Honorable Court of Appeals of Tennessee is in session.
Welcome, counsel. On behalf of Judge McBrayer and Judge Golden, we're happy to have you on the video today. We'll proceed just as if we were all together in the courtroom. It should go fine. If we have any technical glitches, we will stop and get them fixed, and then we will resume. I guess we're ready to call the case.
Metropolitan Government of Nashville and Davidson County, Tennessee et al. Versus Davidson County Election Commission.
All right,
Thank
Mr.
you.
Bumstein.
I'm sorry. Thank you, Your Honor. And thank everybody for allowing me to appear. They do let me out of the university every so often. I appreciate that. I'm James Blumstein, counsel for the appellant of the Davidson County Election Commission, and my co-counsel is Austin McMullen, who's off screen over here. He and I have been retained by the Election Commission and are representing the commission. I've already said I plan to reserve 3 minutes for rebuttal. This is how I plan to organize this, is that I plan to start with the background and information and then to focus on the analysis that we've put forward in our brief and in our reply brief of the City of Memphis case, which we think is controlled.
Ms. Blumstein, let me just ask you preliminarily, because I have some concern about the status of the case, and particularly the issue of mootness, because the way the time frame on this is a little unusual in that the case was originally tried. The case we have before us was originally tried, and I think there was a judgment on maybe the 22nd or 25th of June, and the case was the referendum was originally scheduled for the 27th of July 27th, and the Election Commission canceled that date subsequent to the judgment coming down, and rescheduled it for some date in September. And then that case went to a second appeal. And in that appeal, there was a stipulation by the Election Commission that that date, assuming that date was even valid, that date could not be met. And therefore, the conditions for allowing the election to take place on that date cannot be satisfied, and asked that the case be dismissed as being moot. And so then that left this case that we have before us out there. But I have some concern based on the language of the statute that we've got an impossibility of performance of this referendum at this point. The statute's very specific about the window in which this case the referendum has to be set. And I can't get over the fact that it appears to me that what you're asking for is an advisory opinion here, because I don't see what kind of relief we can give you. I don't see where this court would have any authority under this statute to assuming that we agree with your arguments and we reverse the Chancery Court, to set this for an election. I don't see anything in the statute that gives us that authority. In fact, there's some Supreme Court language that indicates that would require the court to judicially amend the statute, in effect, in order to do that. I don't see how the case is not moot.
Your Honor, can I respond to that question?
Sure.
We have a footnote in our reply brief, footnote 1, that addresses that question. And I don't believe that the commission has ever taken the position that this is moot. Some of the opposing parties and amicus have taken that position. We think it's pretty straightforwardly not moot. The authority of the commission under TCA 23204A exists, and the commission has the responsibility to set the date. And the commission did set the date on July the 27th, and it was blocked by the Chancery Court. So it's pretty straightforward that if we prevail on the appeal under the cases that we cite in footnote 1 on page 16 of our reply brief, the Emory versus Memphis City School Board case, that appellate courts can grant complete relief to the parties, and under Tennessee Rule of Appellate Procedure 36A, the court can undo the order of the trial court and order a referendum election to be pursued, and 23204 A would allow that. So, Your Honor, we think that's a red herring in fairness, is that there is no mootness issue here. The court
by what authority do we have to set this election outside of the original time frame set out in 23204? I don't see that in the statute anywhere that says that. It says that the referendum should be scheduled between 75 no more than 90 days after the county election commission is directed to hold the election under the law authorizing. There's nothing in there that gives that judicially allows that. It doesn't say that if at the end of an appeal or whatever, there's no language like that in here.
But the court is now governed by, it's a remedies question. It's not what the statute says. And the court has broad authority under Tennessee Rule 36A to grant such relief, including the giving of any judgment and the making of any order. So the fact that that would allow tremendous gaming, that any trial court would be able to stop this from going forward. But the courts have authority to grant a remedy, and mootness is just not part of it. The statute itself must yield to the court's remedial authority. Otherwise, any trial court could block this activity by issuing an injunction. So that's just not consistent with the remedies portion of this case.
Well, how does this reconcile with the Supreme Court's case in Wallace v. Metro Government? I realize that's an election case and not a referendum case, but the Supreme Court says that in that case, Metro was suggests that we deem the date of our ruling in this case to be the date on which the officer or body charged with calling the special election receives notice of the facts requiring the call, thereby triggering the statutory time frame for setting the special election pursuant to 214-102. And then they go on to say what Metro and the commission suggest is tantamount to inviting us to judicially amend the statute.
Yeah, we're not asking the court to amend the statute. We're asking the court to follow its authority as a equitable remedy court and to exercise its authority that is conferred by Tennessee Rule 36A. And so ultimately, that would insulate any trial court determination and turn it into a moot claim. That can't be the rule. It's not the rule. Courts have equitable powers to preserve and to give remedy. Otherwise, the court is allowing the case to be torpedoed in a sense, or the issue to be torpedoed once a trial court blocks that. There's no remedy from that under that interpretation, Your Honor.
It seems to me the remedy here was y'all attempted the remedy. The remedy was once the court ruled, then you attempted to have this court pull up the case immediately, have an expedited appeal, and then there was an expedited appeal requested from the Supreme Court. Neither court decided to grant the expedited appeal, and at that point the time ran. In the city of Memphis case, the Supreme Court did pull up the appeal, and in other words, the timing is what's of significance here. And it seems to me that because of the fact that neither appellate court decided to grant an expedited appeal, that's what caused your time to run. I mean, you had to go down the regular appellate process, but I don't see where we have that authority to grant that under the statute.
Well, let me just say, courts under 36A, courts have authority to grant, give any judgment, make any order, and courts have remedial power to go beyond the substantive requirements. And I hate to use the desegregation cases as an example, but the court in the North Carolina Board of Education case allowed the Supreme Court of the United States in that case to order a remedy that was beyond the scope of what would be the substantive responsibility. Courts using their remedial powers are not bound by the same constraints or restrictions. Courts exercising the remedial power in the Emory case and in Rule 36A, Your Honor, are authorized to go beyond the scope of, in this case, 23204. But in this case, 23204 would be complied with, because it would be the court that would be directing the commission to hold the election, and the time frame would then be triggered by the court's order. So if this court undoes the order of the trial court, then it would direct, and that's what we asked for, it would direct the commission to hold the election in the commission's discretion pursuant to 23204A. And that's when the timing would start. It would start from the time that the court overturns the decision, not from the original time, but from the time of the court's determination.
Well, isn't that what the Supreme Court said in Wallace, that we don't have the authority to do?
I don't
Isn't that
believe
exactly
so.
what they said?
I don't believe so. In Wallace, the court ultimately remanded to the commission and gave the commission authority on the date to be used for the holding of the election. So, in fact, the court in Wallace recognized the authority that the commission had to set the date under 23204.
Metro suggests that we deem the date of our ruling to be the date on which the body called the special election.
Well, Your Honor, I'd have to go back and look at the specific language in Wallace. But my recollection of the Wallace case is that in Wallace, the court basically said that the decision for setting the election would be with the election commission, and the election commission would have its authority under its statute. And so once the election was ordered and the court ordered that the election occur, it didn't block the election, it ordered the election to occur, but it then delegated or asked the commission to set the date for the election. I actually think, with all respect, Your Honor, that that's really not a problem under traditional principles of equity and remedy, that this is not the original provision. The original provision was held in abeyance by the court's decision, and if this court undoes that, as I think it should, decision, it can then serve as directing under 23204, directing the activity, and the commission would then be within its authority under 23204A to set the election within the 75 to 90-day window.
So
I'd like to make you feel more comfortable, but I'm not sure that I'm persuading you. But I think that the remedy point is an extremely important one, the ability to issue a remedy to undo the wrong that has been taking place by the court.
Well, isn't this one of those capable of repetition but evading review kinds of cases that the Supreme Court's found exceptions to mootness for?
Yes, Your Honor, it's the same idea. That was a mootness issue for purposes of a decision. And in fact, may I say that footnote 2 in a case called Dunn versus Blumstein establishes that proposition of capable of petition yet evading review. Judge McBrayer,
you
I'm
know
sorry.
about that case?
I'm sorry?
With that case? You're
I think
familiar
I am.
with that case?
Yes.
One of the things I wanted to test out is in the interpretation of 23204A. I mean, it says hold the election under the law authorizing or requiring the election on the question. You know, we're all assuming that that's Metro Charter Section 19, but in this case, it's actually going to be whatever the final judgment is, right?
Yes. And the court has the authority under 23204A to direct the commission, as the court did in the Wallace case, to direct the election commission to set the date. So the commission has the authority, and it would be directed by this court, if the court agrees with us, to undo the chancellor's decision and then to direct the commission to set the date. But we don't think that it fits the remedial powers of a court to be constrained, as was being suggested, by the terms as if nothing has happened. Well, the court blocked this from happening, and this court has remedial authority to undo the blocking, the inappropriate blocking, and then to order the election. I see that my time has elapsed. If the court wants me to continue on, I'm glad. You know, I don't want to be like the boy who knew how to spell banana but didn't know when to stop. So,
well, Thank you, Mr. Blumstein. We'll go to the appellant now, and you'll get your rebuttal time.
Thank you.
We'll go to the appellee now. Excuse me.
May it please the court, Allison Bussell on behalf of the Metropolitan Government of Nashville and Davidson County. This court should affirm the chancellor's decision that the petition is defective under City of Memphis and should not proceed to an election. This court should also conclude that this case has become mooted because no election can be held in compliance with Tennessee Code annotated 23204. I could not make that argument any more eloquently than Judge Golden has already made the argument.
Let me ask you then, what about the concept that 23204 says you're going to hold the election and a law authorizing or requiring the election? The question, I mean, once we decided that question or whatever the authorizing law is, doesn't that become the trigger point for setting the election?
I think
if not, why not?
Sure. I think the trigger point for setting the election is the law authorizing it, originally authorizing a referendum on this question, which is the Metro Charter.
That has to be Section 19 then. So how does one of these questions ever effectively get reviewed? It can only be reviewed under an expedited review. Is that what you're saying?
I think it can be reviewed the exact same way it was reviewed the first time For Good Government petitioned for a Metro Charter amendment. And that's the Election Commission was presented with some opinion, that legal opinion, in fact, that there were some problems with the petition. And so the prudent choice in that situation was to have those legal questions answered by a court. So in what we've been calling 4GG1, the Election Commission filed a declaratory judgment action and asked the chancellor in Davidson County whether this election could proceed. And certainly in a situation, because that option is available, the answer to Judge Bennett's question of whether this is capable of repetition but evading review is no. There's a perfectly plausible way to avoid the quandary that the commission is now in, and that's to seek guidance on the front end. Those same concerns about legality were present in this petition. In fact, some of the very same defects from 4GG1 petition are in this petition. And so that
sounds like, I mean, so if the Election Commission here had gone and asked for a deck action on the validity of this, and let's say that in this case, the court said, instead of what it did say, it said, well, I find this very problematic, but it can be put on the ballot. You're saying that decision then would start triggering the time running, or you're saying that the chancellor then would have to rule within this narrow time frame?
I think what I'm saying is more a response to the argument of whether the court can sort of judicially amend the statute. Certainly the court has abundant authority to do what it chooses. But in a circumstance like this, where there was a more plausible option that could have resulted in compliance, then it doesn't make sense to alter the statute as a remedy to the commission. So if the chancellor had decided either way, then certainly we could have all sought expedited appellate review. But the reality is the commission didn't provide that option because they put a very questionable petition immediately on the ballot without seeking that review.
Well, but I mean, the commission has some restrictions on by this very statute about how quickly it has to put on the commission. And I would think for a good policy reason is to make sure that you don't delay a vote on a referendum. So, I mean, I can't really fault the commission for making a quick decision.
Certainly can't fault the commission for making a quick decision, but if there are concerns about it, they certainly know 23204 exists, and they could have prevented a lot of the quandary that they're currently in by seeking the answers to those questions in advance instead of making what amounted to legal conclusions in their decision that this should proceed to an election. And once the commission makes that decision, the Metro government at that point has no choice but to seek judicial intervention to stop an election that is unlawful out of the gate. The election just should not proceed, which of course is the question that City of Memphis gives courts the ability to answer pre-election. So the Election Commission implores you not to examine the contents of this petition. They don't want to talk about what the petition says. And they argue that the chancellor should not have examined the contents of this petition. But the commission's argument misunderstands City of Memphis. In City of Memphis, the Tennessee Supreme Court pronounced the general rule that governs this case. And that is this: challenges to the form or facial invalidity of a ballot measure are ripe for pre-election review, while challenges to substantive unconstitutionality are not ripe. And regardless of where those individual lines are drawn, one thing is very clear here. It is indisputed that the chancellor properly considered whether the petition met the requirements of Metro Charter 19.01. And one of those requirements is that the petition shall prescribe a date for the referendum election, not 2 dates as the Election Commission chose. The Election Commission prescribed 2 dates just in case they couldn't get enough signatures to satisfy their first date. And therefore, the chancellor properly declared it defective in form. And this case can be affirmed on that finding alone, because if you don't comply with the technical requirements of the Metro Charter for a referendum to amend the charter, then the election cannot move forward.
And what is the harm? I detected something in Metro's brief that there was some harm that was trying to be avoided by having multiple dates. What's the harm here when there are multiple dates?
Absolutely. Well, the harm is it's very analogous to all the cases such as Coella, Lanier, State Ex Rel Cassidy, where you've got a firm filing deadline, and those filing deadlines essentially set the time frame for what has to happen after that. A petition to amend the charter effectively works the same way. The only mechanism for setting the date at the outset is that a date requirement. The petition itself has to include a date. And that date is what triggers the deadline for collecting signatures. Well, the signatures are everything when it comes to a petition, right? You've got to collect enough signatures for the petition to move forward to election. And so permitting 2 dates, which is what was done in this instance, effectively creates a backup plan. It's plan B. If we can't get enough signatures the first time, then we've got another date here included to give us another chance. And in fact, reversing the chancellor on those grounds, what would prevent someone from including 10 dates or 50 dates or no date for that matter? If it's not a strict requirement, then you've eliminated any plausible deadline for the collection of signatures, which again is the whole point of a referendum petition. You've got to collect the right number of signatures, and the Metro government and the citizens of Metro Davidson County are entitled to some ability to predict what's going to happen. And,
but I guess that's what I'm having trouble understanding isn't the ultimate protection against that is because the signature numerosity requirement is based on the last Metro general election. It really doesn't matter what date they pick because you're always looking retrospectively to what the last Metro general election was to determine the signature requirements.
Right, but the point is not just to determine which election determines how many signatures you have to have. The point is to create a deadline for collecting those signatures, right? Because what would preclude someone from carrying a petition around Metro Davidson County for 2 years collecting signatures? In fact, 2 years down the road, that issue may not even be a relevant issue. But meanwhile, the Election Commission, the Metro government officials and department heads, and in fact, the other citizens in Metro are sitting around twiddling their thumbs, waiting to know, when is this thing going to actually be a live issue? We effectively have created a free-for-all in terms of the way we amend our charter. And that a date requirement is the only mechanism in the charter for preventing that. It gives some certainty to people who are signing petitions. It gives certainty to the Metro leaders who are making decisions about how money's going to be spent and what moves should be made. And it creates a deadline for the petitioners to actually have to meet the requirement of getting those signatures in place. But even if the court were to conclude that the technical requirement in section 19.01 should not be applied strictly here, and that petitioners could have as many dates as they chose on a Metro Charter amendment petition, the court may also affirm the chancellor below because there were multiple individual provisions, proposed charter amendments, in fact, that are defective under City of Memphis. In City of Memphis, the court cites cases such as Burnell out of West Virginia, Donovan out of Arkansas, and Alaska Conservatives PAC out of Alaska. And all of those cases, in fact, City of Memphis cites Burnell as applying and explaining the general rule about when a matter is ripe for pre-election review. And what we see in those cases is that where certain subject matters cannot be addressed by referendum for whatever reason, then ballot measures that encompass those subject matters can be reviewed pre-election. And that's exactly what happened here. And then the second reason that proposed amendments in this petition were defective under City of Memphis is because state law, Tennessee state law, requires ballot measures to be written in a way where they have reasonable certainty of meaning, such that voters who are looking at that proposal can understand the consequences of their vote. And so for both of those reasons, those individual provisions are defective. And in fact, the petition also importantly did not contain a severability clause. And this is key because the commission argues in its reply brief, it addresses Burnell for the first time in this case, in its reply brief. And it says, yeah, but wait, Burnell, the court in Burnell said for the election, to be held up, the petition has to be invalid in its entirety. So even if you have one provision, for example, I think it was section 4.05 of their charter could have been a proper subject matter, while section 8 of their charter was not a proper subject matter. In Burnell, the court said, well, one of those could move forward. Therefore, we're not going to stop the election. This case mandates the opposite conclusion because there is no severability clause. If you look at Burnell, the court specifically mentioned the severability clause in that petition and said, we can't parse out the viable provisions from the ones that are not viable. In our case, the opposite is true. The only severability clause in this petition is within proposed amendment 1, which was the limit tax rates provision. There is no severability clause that would have applied to the measure as a whole that would allow the court to pull out the proposed amendments that were viable. And as a result of that, applying the plain language of Burnell, again, which City of Memphis says applies and explains the general rule, this case should be affirmed. The chancellor properly concluded that there are defective amendments. They are not proper subject matter for referendum. Therefore, the injury is the election itself. Now, the commission would have this court believe that if you have to look at the substance at all, if you have to read the words on the page and understand what they mean, that's a substantive unconstitutionality analysis. And therefore, the court would not have, it's not justiciable, it's not a ripe issue. And that's incorrect for a number of reasons. First of all, if you take a look at Brown, which is the case that's cited in City of Memphis, you'll see that that was a caption clause issue. And the question before the court was, is the body of the ordinance broader than the caption? Because if so, then the election can't move forward. And Brown didn't say, well, that would require us to read the substance, and we can't do that pre-election. Brown said, we can't have an election because you can't have an election on a matter that facially violates the caption clause. And so Brown establishes that this court can and in fact should review the measure to determine whether it is a proper form for a referendum. And then we also take a look at cases like Burnell and Donovan, and they give us a really clear delineation between what is ripe pre-election and what is not ripe pre-election. For example, in Burnell, we see that the question is whether the referendum is legally authorized. So the Metro government is not arguing that these things, if adopted, will be unconstitutional. The Metro's position is that for it to be permitted to be reviewed pre-election, the question is whether the measure can be adopted in this way. For example, if you can't address taxes in a county through a referendum, then you can't have a referendum because the injury itself is the election. If you allow that election to move forward, the injury has already occurred. And then in Donovan, things that you discover after the election aren't going to sharpen the issues. The question is, can they use direct legislation, the direct legislation process in the first place? So it appears that I have run out of time. We will certainly reiterate to the court that this case is moot for the reasons we've described. And certainly the chancellor's opinion should be affirmed as because the petition was defective under City of Memphis.
Thank you very much. Mr. Blumstein, you have your rebuttal time.
Thank you, Your Honor. I would like to hold off the mootness point to the very end. I'm not sure I succeeded in addressing Judge Golden's concerns, and I want to do that as a teacher. I want everybody to understand our position. So with some indulgence, I'll put that to the last because we did speak to it. I want to address 5 points in response. First, the petition is a form of popular democracy. There's a lot of discussion by Metro and by the court that somehow popular democracy is not part of the Tennessee political process. In our brief, we assert and show that it is. There can't be a charter that's approved without the vote of the people, and there's a requirement for Metro that there be a process for amending the charter, and that process include a vote of the people. So having a vote of the people, some form of popular democracy involved in the process is not foreign to, but part and parcel of. Secondly, Ms. Bussell says the commission should have asked for guidance, but it has the option to ask for guidance, but it's not required to do so. The Pemberton case makes that pretty clear, that this is a discretionary act, and there are consequences of moving for guidance. The commission loses the advantages of a writ of certiorari procedure if it uses the declaratory judgment action. And there's no requirement that the commission seek guidance before approving this referendum. There's a duty to approve the referendum if there's enough signatures and there are no other problems. There's no requirement to seek judicial guidance. And until the first one of these four good government proposals, that did not occur. The City of Memphis, in our reply brief, has this prong 1 and prong 2 analysis. Prong 1 is non-substantive. It's technical or procedural, such as a caption requirement. Prong 2 is a substantive review, but it requires a facial invalidity. So there is the ability to look at substance, but in a very narrow, circumscribed way. Metro's proposal and the chancellor's proposal would really undo that. It would open up substantive review beyond facial invalidity, which is the hardest type of claim to satisfy. The severability point, this reminds me of the Bill of Rights. The Bill of Rights rose and fell based upon each member, each one of the Bill of Rights. They were put together as a package, but there was no severability issue. If the people ratified one, then they ratified one. If they didn't, then they didn't. But they didn't rise or fall together. Same thing's true with these amendments. They are separate and they don't rise or fall together. So severability, in our view, is a paradigm error that the chancellor made. I see that I'm out of time. I don't have time to get to the mootness or the prescribed date point. Let me just, if you will indulge me one moment in closing, and that is that at this point, what's the harm? I just pick up on Judge McBraier's point. No date from the petition is binding. The July 27 date was blocked by the trial court. If the commission prevails, the Court of Appeals can direct the commission to hold the election in compliance with 23204. Where's the harm or the prejudice at this point to what's being challenged here? The harm is the blocking of the referendum. 12,000 people, more than 12,000 who signed these petitions will not get their vote. And it risks, as we say in the brief, the perception that courts distrust the people and that popular democracy is subject to challenge and distrust. I think it would be a very bad outcome, and it would suggest that the courts are trying to hide something, Metro's trying to hide something. Let the people have their say.
Thank you, Mr. Blumstein. Thank you, Ms. Bussell. You've given us a lot to think about, and we appreciate that. Ms. Dempsey, would you close court?
This honorable court is in recess